If you have a green card, you are applying for one, or your family or employer is sponsoring you, you have probably seen headlines saying Congress approved a major new U.S. immigration law and that green card holders must watch. Here is the most important thing up front. Even when Congress passes something, most real-world changes do not hit your case the same day. What matters is what the final law actually says when it takes effect, and what guidance USCIS and the State Department publish afterward. In this video, I am going to separate what we can reasonably verify in a situation like this from what is often assumed online, and I will give you 3 concrete takeaways by the end. 1. The specific areas where green card rules typically change and what that would mean for you. 2. Who is likely affected versus who is usually not. And 3. A practical checklist you can use right now so you do not get surprised by a deadline, a travel mistake, or a missing document. Here is the part most people miss. The scariest headlines are usually about the biggest possible interpretation, but immigration changes are normally implemented through phased effective dates, updated forms, and updated officer guidance. If you plan correctly, you can reduce risk even before the details are fully clear. Now, because your brief says Congress has approved significant new legislation, but does not include the name of the law, the text of the changes, or the effective date, I am not going to pretend we have details that are not provided. Instead, I will walk you through the common categories of changes that legislation can create for green card holders and applicants, and I will show you exactly how to monitor the official sources so you can confirm what applies to you. If you stay with me, you will know what to do even when the news is moving fast. First, what does it mean when people say Congress approved an immigration law? In the U.S. system, a bill generally has to pass both chambers and then be signed to become law. After that, agencies like USCIS and the State Department often need time to publish implementation guidance, updated instructions, updated forms, new policy manual language, and sometimes new fee rules or new procedures. Some laws have immediate effective dates. Others have delayed effective dates, or they apply only to applications filed on or after a certain date. And some parts require regulations, which can take longer. So when you hear approved, the next question is, approved and effective when, and for which filing dates? This matters because it determines whether you need to change something now or just prepare and watch. This is where people get denied or delayed. They assume a rule changed for everyone immediately, make a rushed decision, and then later learn there was a transition rule or a grandfathering provision. So, keep one principle in your mind. Do not rely on summaries alone. Always verify the final text and the agency instructions tied to your form type. Next, let us ground this in green card basics so the rest of the video is clear. A green card holder is a lawful permanent resident. That status is what matters. The plastic card is evidence of the status. People confuse those two all the time. For example, an expired physical card does not automatically mean you lost status, but it can create major problems for travel, employment verification, and benefits access. Also, there are different pathways to a green card: family-based, employment-based, humanitarian, and other categories. For many viewers, the big processes are adjustment of status inside the US and consular processing abroad. Those pathways use different steps, different timelines, and different risk points. One more key concept: eligibility rules and procedural rules are different. Eligibility is whether you qualify. Procedure is how you prove it and what steps you follow. Laws can change either, and sometimes both. Here is the small detail that changes everything. A procedural change can still delay you for months, even if you still qualify, because the evidence standards change, interviews expand, or background checks require additional steps. Now let us talk about what may change in 2026 if a major law affects green card holders and applicants, without making up specifics that we do not have. In most large immigration bills, changes tend to cluster into a few areas. First, USCIS processing procedures, including interview rules, evidence requirements, and fraud prevention steps. Second, employment-based green card mechanics, such as portability rules, job offer documentation, and how backlogs are managed. Third, Family-based provisions, including sponsorship requirements and how relationships are documented. Fourth, green card maintenance, like renewal processes, address reporting, or travel-related rules. And fifth, the path to naturalization, like eligibility timing or documentation expectations. If you are hearing that green card holders must watch, that typically signals attention to maintenance and compliance. Travel, criminal issues, address changes, and renewal. Not because everyone will lose their green card, but because enforcement and documentation standards can tighten. Let us break it down into who is affected versus who is not, because that is the quickest way to reduce panic. Group 1. Current lawful permanent residents who live in the U.S. and do not have unusual travel patterns or unresolved legal issues. In many legislative updates, your day-to-day life may not change immediately. You may still want to check your renewal timing, your address history, and your travel plans. But you are usually not required to file something new out of nowhere unless the law specifically creates a new requirement. Group 2. Green card holders who travel a lot or spend long periods outside the U.S. You are more exposed to rule changes because re-entry decisions involve CBP at the border, and long trips can raise questions about whether you abandoned residence. Even without any new law, this is already a major risk area. If new rules tighten documentation expectations, this group feels it first. Group 3. Conditional permanent residents, like some marriage-based cases with conditions. You already have critical filing deadlines to remove conditions. Any procedural change could affect evidence checklists or interview practices. Group 4. People in the pipeline, meaning you have a pending adjustment of status application, a pending immigrant visa case, or a pending petition like an I-130 or an employment petition. You are affected by procedural updates more than anyone because new forms, new instructions, or new evidence standards can apply to filings after a certain date, and sometimes to pending cases when USCIS issues new guidance. Group 5. Sponsors and employers. Even if you are not the immigrant, you may have to provide updated evidence, updated financial documents, or respond to additional verification steps. Now, who is usually not affected in an immediate life-changing way? Tourists, short-term visitors, and many non-immigrant categories may not be directly impacted by green card-specific provisions. Also, if you are already a U.S. citizen, green card maintenance rules do not apply to you, but family-based processes could still affect your relatives abroad, so citizens should still pay attention if they are petitioning. Here is a quick myth versus reality moment. Myth: if Congress approves a new immigration law, all pending green card applications automatically get denied or re-reviewed. Reality: most of the time, cases continue under the rules and procedures that apply to their filing date, unless the law or agency guidance specifically says otherwise. Myth: your green card expires and you instantly lose status. Reality: the card expiring is a documentation problem, not always a status loss, but it can trigger serious practical problems and delays, so you should plan renewals early. Myth: a small arrest that did not lead to a conviction never matters. Reality: immigration looks at arrests and dispositions, and you should have certified court records and consult a qualified professional if anything exists in your history. Next, why would changes like this happen? Usually, it is a mix of backlogs, fraud concerns, workforce and family unification goals, and political pressure to standardize enforcement. USCIS is a benefits agency, but also runs identity and security checks. When backlogs rise, agencies may change processes to triage, automate, or require more complete submissions up front to reduce repeated requests. When fraud patterns rise in a category, you see more interviews, more evidence requests, and more scrutiny. And when demand surges in employment-based or family-based categories, you can see ripple effects into the visa bulletin and timing strategies. Here is the key: even if the law intends to make things faster or fairer, the transition period can still create confusion. New forms can roll out, old additions get rejected, and processing times can spike temporarily. Now let us get concrete about real-world consequences, because this is where viewers need practical planning. Number 1. Travel. If you are a green card holder and you plan to travel internationally, keep your documentation clean and current. A new law might not change the basic principle that long absences can raise abandonment questions, but it could change how strictly officers ask for proof of ties to the U.S. Practical impact. You might be asked more questions at entry, or you might be referred to secondary inspection more often. This does not mean you did something wrong, but you should be prepared. Two groups are at highest risk here: people who routinely take long trips abroad, and people who have a pending naturalization application and think travel does not matter anymore. It does. Number 2. Renewals and replacements. If there are changes to renewal requirements, even small ones like updated identity verification steps, it could create a rush that increases processing times. That can affect employment verification and travel. So you want to renew early when allowed, keep evidence of filing, and plan travel around it. Number 3. Applicants in process. If USCIS changes its evidence standards, you might see more requests for evidence. That can delay work authorization and travel documents if you are adjusting status. If you are consular processing, updated documentation requirements can mean additional steps before an interview or after an interview. Number 4. Employment-based cases. Job changes, promotions, location changes, and employer reorganizations can all create complexity. Even if you are eligible, timing and documentation matter. If the law changes how portability works or what evidence is required, a job change at the wrong time can create a setback. Number 5. Family-based cases. If there are changes to sponsorship evidence or relationship evidence standards, you may need more documentation than you expected. It does not mean you cannot qualify, it means you need to be organized. Here is an example scenario to make this real. Example Scenario 1. Lena is a green card holder who visits her parents abroad twice a year. One trip becomes longer than planned because of a family emergency. She returns and CBP asks detailed questions about where she lives and works in the U.S. If new guidance encourages stricter review of long absences, Lena can reduce risk by carrying updated proof of U.S. residence and employment, keeping her tax filings consistent with residence, and avoiding patterns that look like she lives abroad. Again, that is not legal advice, just practical planning. Example Scenario 2. Marcus is adjusting status through an employer and has a pending application. He assumes nothing can change once filed, so he ignores updates. Then USCIS releases updated instructions for a form edition, and his response to an RFE uses outdated language and misses a key document. His case is delayed. The fix is boring but powerful. Monitor your case type pages, read the exact RFE checklist, and respond with a clean, indexed packet that matches the request. Now we get to the most important part: what to do now. I am going to give you a do this versus avoid this checklist that is safe even when details are still emerging. Do this. Track your exact status and stage. Are you a green card holder renewing a card? Are you applying for naturalization? Are you a pending adjustment applicant waiting for biometrics, an interview, or a decision? Different stages have different risks. Do this. Create a one-page timeline for your case. Include filing dates, receipt notices, biometrics dates, interview dates, travel dates, and any address changes. If a new rule applies based on filing date, you will know where you stand immediately. Do this. Make a document folder now. Keep copies of your notices, your current and prior immigration documents, your passport biographic page, your travel history, your last several tax transcripts if available, proof of residence, proof of employment or school, and certified court dispositions if anything exists. This is where people get stuck. They wait until they are asked, then they cannot get records in time. Do this. Keep your address updated with USCIS if you have a pending case, and keep your mailing reliable. A surprising number of delays come from missed notices. Do this. If you are traveling, plan for re-entry like an interview. Carry evidence of ties to the U.S. that makes sense for your situation, and keep your trip lengths reasonable if possible. Avoid this. Do not make irreversible decisions based only on viral headlines. For example, do not abandon an application, do not quit a job, and do not cancel travel without first verifying whether a real effective date or rule exists. Avoid this. Do not file a form using an outdated edition if a new edition is required. Always download forms from official sources right before filing. Avoid this. Do not assume that because your friend had an easy interview, yours will be the same. Small differences in history, travel, or documentation can change outcomes. Avoid this. Do not ignore requests for evidence or interview notices. Late or incomplete responses are a common reason for denial or long delays. Do this. Monitor the official places where changes show up first. That includes USCIS official announcements, the USCIS policy manual updates, form pages for edition dates and instructions, processing times pages, and the State Department for Immigrant Visa Processing and the Visa Bulletin when relevant. If a law truly changes a requirement, you will usually see a chain reaction in those places. Here is another myth versus reality moment. Myth: if a new law tightens rules, the safest move is to file anything immediately before the deadline, even if it is incomplete. Reality: an incomplete or poorly documented filing can create years of problems. A timely, accurate filing is better than a rushed one. Myth: only USCIS matters. Reality: if you are traveling or consular processing, CBP and the State Department can be just as important for how rules are applied in practice. Now, what should green card holders specifically watch in 2026, based on how these rollouts usually happen? Watch point 1. Effective date language. Look for whether changes apply to applications filed on or after a date, or whether they also apply to pending cases. Watch point 2. New forms or new form additions. Even when the eligibility rule does not change, the form can. Watch point 3. Fee changes or fee-related instructions. A mismatch can cause a rejection. Watch point 4. New interview or biometrics practices, including expanded scheduling or reuse policies. Watch point 5. Visa Bulletin movement if employment-based or family-based demand is affected. Even a procedural change can shift demand and timing. Watch point 6. Public guidance like FAQs. When a major change is real, agencies often publish FAQs to reduce confusion. Here is the part most people miss. There can be a surge effect. News of changes often triggers a wave of filings. That can slow processing temporarily. If you are planning something time-sensitive like international travel, a job start date, or a school term, build in extra time and keep backup plans. Now, a quick common questions segment based on what green card holders and applicants usually ask during big news cycles. Question: do I have to do anything today? For most people, the answer is no, not today, unless you have an imminent deadline like a renewal, a response due date, or planned travel. Your best move today is organizing, verifying, and watching official updates. Question: will this affect naturalization? It depends on what the law changes. Many people can continue to apply under existing rules unless the law changes eligibility or documentation. But even without new law, naturalization cases can be delayed by travel history, taxes, selective service issues where applicable, or missing records. So your preparation still matters. Question: can I lose my green card because of this law? Losing permanent residence usually involves specific legal grounds and processes. Most law changes do not strip status overnight for compliant residents. The bigger risk is unintentional non-compliance, long absences, missed filings, or confusion about requirements. Question: should I travel right now? If you have a green card and you are in good standing, travel is generally possible. But make decisions based on your personal facts and current official guidance. If there is any complexity in your history, get qualified help before traveling. Next, let us talk about what could happen next, because uncertainty is what drives anxiety. There are a few realistic paths. Path 1. The law exists, but implementation is gradual, with USCIS issuing guidance over weeks or months. Path 2. The law includes immediate changes for certain filings, so you may see a cutoff date. Path 3. Parts of it face court challenges or require additional regulations, which can slow or pause certain provisions. Path 4. The practical impact is mostly administrative, meaning more documentation and longer processing for a period, rather than a big eligibility shift. Because we do not have the text in your brief, the smart approach is to prepare for the administrative impact first. That is the most common, and it is the most manageable with good organization. Before we close, here is the final 5-part recap in plain English. 1. Do not panic from headlines. Confirm what is real, what is rumored, and what has an effective date. 2. Know your category and stage: holder, conditional holder, pending applicant, sponsor, or employer. 3. Protect yourself on the basics that never go out of style: timely renewals, accurate addresses, clean documentation, and careful travel planning. 4. Expect a transition period. Updated forms, more evidence requests, and temporary delays are common during rollouts. 5. Watch official sources and build a personal checklist so you are not reacting at the last minute. If you want, comment with your situation in general terms, like green card holder renewing, family-based applicant waiting for interview, or employment-based adjustment pending, and I will tell you which watch points matter most. And if this video helped you feel more in control, subscribe and turn on notifications, because when real, verifiable USCIS guidance drops, the people who see it first are the ones who avoid the preventable delays. Until then, stay calm, stay organized, and verify everything with official updates.